All right. Thank you, everybody. It is just gone 2 o'clock, and may I welcome you all formally to this afternoon's webinar, which is being hosted by Next Start, and I will introduce our illustrious panelists in just a moment. The subject matter of the webinar is the forthcoming Business and Planning Bill, currently making its way through Parliament even as we speak, and the particular topic for this afternoon is the introduction of pavement licenses, which is one of the particular facilities that this bill is going to introduce. And speaking of introductions, may I introduce myself? For those of you who don't know me, I'm Sarah Clover, and I'm a barrister at King's Chambers, and I'm based in Birmingham under normal circumstances. And my special areas are licensing and planning. And I'm part of the licensing team at King's Chambers. And I am ably joined there by Leo Charalambides, who is a joint tenant at King's, but also Francis Taylor Buildings in London. And Leo specialises in all aspects of licensing, local government law and related matters, and is well known to many of you, I'm sure. And may I also please introduce Charles Holland. Very grateful to have Charles with us. Another very well-known name, another stellar licensing lawyer, also local government law and related areas, and based in Trinity Chambers in Newcastle, but also Francis Taylor Buildings in London. And welcome to our panelists this afternoon. And I'm just going to set the context and chair events, but I will be turning to Leo and Charles in just a moment to give us some more specifics. This is a hastily convened webinar under the circumstances. Things are moving at great pace at the moment. This will not be lost on any of you. Trying to keep up with current events has proved extremely challenging. And the context for all of these matters is, of course, the COVID-19 pandemic. And we have been struggling in it, and we are hopefully just about to experience what it looks like to come out of lockdown so far as hospitality premises are concerned on Saturday, 4th of July, and I'm sure we're all excitedly looking forward to that day. Perhaps if not excited, then trepidation would be another word, but in any event, it is coming. And so is the Business and Planning Bill, with all the different facilities that will introduce for us. And we need to get ready, and we don't have a great deal of time to do it. Hence the webinar this afternoon. Hosted by Next Start, might not be a familiar name to you. Next Start, also a fairly hastily convened team, a think tank put together back in April, comprising a number of the different trade membership organisations, some of the big ones and some of the smaller ones as well. People like UK Hospitality, BBPA, BII, Nighttime Industries Association, Music Venue Trust, and many more besides, those representing outdoor venues and events, festivals, the arts, and so on, trying to collate as many different stakeholder interests under the flag of hospitality as possible, and also bringing them together with the regulators. So we're a think tank working together with the National Police Chiefs Council and the Local Government Association, Institute of Licensing, Institute of Acoustics, NALIO, and others as well, to try and consult and come up with thoughts, suggestions and ideas that we can feed into government and elsewhere to try and smooth the path of these very, very difficult times, and being particularly acutely felt by the hospitality industry, with whom, of course, many, if not all of you, work on a regular basis. And trying to keep up with all of these changes that are continually bombarding us, whether that's the government's COVID secure guidelines, or whether now as they have embarked upon a piece of statutory legislation, which is going to take some grappling with. Now, there are two elements of the Business and Planning Bill that have particular relevance for the licensing world. One is in relation to off sales. We will not be talking about that today, but we did want to talk about pavement licenses. And this is really linked to some widespread press and lobbying and pressure that you may have been following concerning the campaigns for getting outdoors to facilitate premises in their social physical distancing requirements to try and cut down on the transmission of the virus, to use outdoor spaces so that they can get people further apart so that natural ventilation can cut down on transmission. So there have been a number of campaigns and lobbying efforts to try and use outdoor space, and the government clearly felt that this needed to be coordinated at national level, and they're not wrong about that, and needed to have some legislation that would actually facilitate this aspiration. So the great al fresco revolution, which will of course last approximately as long as the sun does in most instances. And then we have another issue on our hands as to where people will go from the outside to the indoors, but that's a different story. So we're going to get everybody outside. That's what this part of this bill is supposed to be all about. Now, it's not the first time ever, of course, that licensed premises have been given the opportunity and the facility to use highways pavement for outdoor dining and to put furniture, pavements and pavement licenses, chairs and tables, that kind of thing. We are familiar with that concept in pre-existing legislation, but it's quite a knotty little area, this, because the simple act of putting tables and chairs on a pavement bumps into potentially about 5 different pieces of legislation, whether that's licensing, planning, street trading, Highways Act, whatever it might be. It's not the most straightforward thing in the world, and I think a lot of you will be aware of that, and will be aware of the split between the authorities that normally deal with these sorts of things, not typically dealt with at district level, sometimes dealt with at county level, highways level. So trying to translate what has been and what we are used to into this new model, this new facility that premises can use, is taking a little bit of getting used to. And that is what this webinar is all about. So with that little bit of explanation about Next Start as a group, and Charles and Leo and myself are all 3 participants in Next Start, and the context of the bill overall, we'll dive in. You've got the chat function, which I can see that you're using. We do have some questions that have been sent to us in advance, but this is really your opportunity to ask the questions that you want to ask this afternoon about pavement licenses. So do take that opportunity. If you can drop those questions into Q&A, I will try and deal with those who are raising hands. I'm going to allow our panelists to speak first, if that's all right, and then we will try and pick up the questions, and I will facilitate that for you. One last point from me, I suppose, is everybody's asking, when will this act be passed? And the simple answer is we don't know. It is being fast-tracked. It has been fast-tracked through the Commons, and we are expecting it to make rapid progress, but our definition of rapid progress and the Lords and the Commons definition of rapid progress may not necessarily be the same thing. So we simply do not know how quickly it's going to be. I understand it's in the Lords on Monday. More than that, we cannot particularly say at this time, but fingers crossed. So without further ado, am I coming to Charles first? Was that our plan? Lovely. Well, I will pass over to you, Charles, and then I will pick up on the chat and the Q&A, and over to you. Thank you so much.
Thanks, Sarah, and good afternoon to all 243 of you. Really terrifying. I'm going to very briefly just give an overview on what a pavement license is or will be when the Act receives royal assent. It's a new species of license labelled a pavement license. What it does is to permit the operator of a business selling or intending to sell food or drink, whether exclusively or otherwise, to put furniture such as tables and chairs on part of the highway adjacent to their premises to sell food and drink from and or for their customers to use. an appreciation of the import of that permission requires an understanding of the existing regimes. And as Sarah's already said, the existing regimes are something of a mishmash. To put tables and chairs on a pavement potentially engages 3 species of regulatory permission. And I'm going to deal with those in turn. The first is the Highways Act 1980. The second is planning under the Town and Country Planning Act. And then finally, the jumble of what is street trading legislation in the provinces and the metropolis. And just to make it easy, different local authorities take different approaches as to what an operator requires in order to put tables and chairs on the highway. The first thing that has been required in the past is a permit under the Highways Act 1980. That is confusingly already known as a pavement license. It's also known as a street cafe license and a table and chairs license. I'm going to call it a Highways Act permit, and it's found in Part 7A of the Highways Act 1980. And a local highways authority may grant permission to use objects on the highway which would result in the production of an income under Part 7A of the Act. Highways include pavements. A highway is defined under Section 328 of the 1980 Act as including the whole of the highway, and it's well established that includes pavements. And unless you have a Highways Act 1980 permit, if you put tables and chairs on a pavement, you are potentially committing an offence of willful obstruction of the highway under Section 137 of that Act. The Highways Authority is the council of a county or the metropolitan district. So in the 22 two-tier counties of England, the Highways Authority is the county council and not the underlying district council. In London, responsibility generally lies with the 32 London boroughs, although TfL has responsibility for GLA roads. It is the Highways Authority for that in London. They're trunk roads. There generally aren't many pavement cafes next to London's trunk roads, but that technical quirk is there. It's not every type of highway that a highways license can apply to. There are a list of definitions. If you want to go and look at them, it's in Section 115A of the Act, but it includes pavements, highways in relation to which a pedestrian planning order is in force, highways whose use by vehicles is prohibited by a traffic order. It doesn't include roads that have been temporarily closed for purposes connected to coronavirus, but the new pavement license will now, thanks to an amendment made on Monday, covers those. Applications for Highways Act permits made to the relevant local highways authority. They're subject to consultation. Conditions can be placed on them. Fees are payable. Then there's planning. Most local planning authorities generally take the view that the placing of tables, chairs, and the like on the public highway constitutes a material change of use. And so when you apply for your Highways Act permit, you have to make a separate application for planning permission for development under the Act. And then finally, street trading. The legislation in London defines street trading more widely than in the provinces. So in London, street trading doesn't just include the selling or exposing for sale of any article, it includes the provision of services. And so in addition to a Highways Act license and in addition to planning permission, many London boroughs, but not all, choose to require a street trading license, which is either under the London Local Authorities Act or if you're in Westminster, under the City of Westminster Act. And just to make it fun, those three combinations are not uniformly applied by London boroughs. In the provinces, street trading generally isn't engaged, but that's not to say it's irrelevant. The exposure for sale of an article falls within street trading. So if Miss Miggins puts a cart with Miss Miggins's pies on outside Miss Miggins's pie shop in the provinces, that is going to require, or that would require, a street trading license. But the purpose of the new regime is to provide a fast-track procedure for the grant of an authorization that's going to bypass all three regulatory regimes existing. So what will happen when the bill gets royal assent is that anything done by a license holder pursuant to pavement license doesn't need a Highways Act permit. And furthermore, it's deemed to have planning permission, and it's defined as not being street trading for any street trading activity. That is essentially what a pavement license does. It doesn't add any more licensing authorizations than that, nor does it alter any existing licensing authorization. An applicant is a premises user with the necessary actual or proposed use adjacent to the relevant highway. So it's quite wide. An applicant needs to use or propose to use premises for or including a relevant use, and a relevant use is either use as a public house, a wine bar. There's a sort of wonderful trend in these regulations to insert concepts previously unknown to licensing law, so answers on a postcard as to what a wine bar is, or other drinking establishments, which covers everything. So either a use as a public house, wine bar, or other drinking establishment, or other use for the sale of food or drink for consumption on or off the premises. And in our view, that is quite wide. It doesn't just cover traditional hospitality sector venues. It could cover basically any unit that can dream of an intended use of a food and beverage element. So an art gallery, a hairdresser, and so on. All they need to do is propose a partial food and beverage element. A premises license under the Licensing Act 2003 is not required to make the application. Then your premises needs to be adjacent to a relevant highway in order for you to specify an area as to where you want the premises license to have effect. Our view is that adjacent to the premises does not mean contiguous to or abutting. There can be a gap between the premises and the part of the highway where the premises, where the pavement license is to take effect. And the word adjacent was used in the regulations closing beer gardens. Not all beer gardens abut or are adjacent to a pub. And I think what's sauce for the goose is sauce for the gander, and the other way around, they don't need to be abutting. The license authorizes the placement and use of removable furniture for defined purposes, and the defined purposes are either or both of A, selling or serving food or drink supplied from or in connection with the relevant use of the premises, or B, by other persons for the purposes of consuming food or drink supplied from or in connection with the premises. Furniture is defined in the bill. I won't bore you by reading it out, but in essence, the pavement license doesn't just permit tables and chairs for customers. It includes things like counters or stalls, and I would say bars, for selling or serving food or drink. But again, I remind you, this doesn't add any licensing consent. All the pavement license does is deal with not obstructing the highway, planning permission, and street trading. So if the red line is not on the highway, and it probably won't be on the highway, you can't just put a bar there under the and start selling from it under the authority of the pavement license. The pavement license only allows the placement, the temporary placement of furniture, and deems that to have planning permission and takes it out of the street trading regime. All things in relation to alcohol still remain under the Licensing Act 2003, and either have to fall within off sales, and we can have interesting questions about where alcohol is appropriated to contracts, or there needs to be a temporary event notice or a variation to move the red line. So hopefully, in a nutshell, that's what a pavement license does. It bypasses those three regimes. It does nothing more, doesn't allow alcohol to come in, doesn't alter the permitted hours on the existing premises. And Leo's now going to tell us how you apply for such a beast.
Good afternoon, everyone, and welcome. If I could just say, one of my takeaways in respect of the COVID-19 period has been what a pleasure it's been to sort of work in partnership and collegiately with so many colleagues. I've already had the benefit of experiencing that, being a tenant at both FTB and King's. And so I, managed to have my cake and eat it, and effectively am a member of 2 households before it even got trendy. And I can definitely say that the support bubble that provides is immense. And so I'm really grateful to so many colleagues who've set up WhatsApp groups, forums, the NTIA, Next Start, for which Sarah needs to be given credit, and so on, because talking together in this way is so beneficial and is a real credit to our entire licensing community. So in terms of that, it's great to speak to the note that we worked on with Sarah and Charles. And I'm just going to briefly talk about the application itself, because I really want to get to the questions which are coming thick and fast. The first is to do with the information that needs to be given in the application. We're told we need to specify the premises, the relevant part of the highway, and this really touches on Charles's point about what is adjacent, and a number of you have raised questions about, well, does it have to touch the premises? Can it be near to the premises? How far away from the premises? So that supports our contention that identifying a suitable bit of the relevant highway could be part of the process. How it intends to be used, because we can see it's food and drink, or proposes for food and drink, and a variety of furniture. So explaining what we're going to use it for. Is it going to be a table to extend seating? Is it going to be to have an outdoor servery area where people can then take food or drink to take away? Is going to be important. When is it going to be used? So we've had questions about duration and use. So for example, I could apply and get my duration for up to a year, but I might want to only use it at the weekends, in which case that can be conditioned. The importance of the type of furniture, so whether they'll include umbrellas or outdoor heaters, is going to be really hugely important and impact on our risk assessment. The date of the application, obviously, because the date is crucial given the time limits involved, public liability, insurance, and any other material or information that the local authority is going to request. And we're not quite sure what that will be, so it's going to remain important for us all to think about and look at what local authorities want. But the guidance itself also goes into some detail about additional information, things like a plan. I think a plan is going to be very useful, particularly given what's already happening on our streets and public spaces, even before we've eased lockdown and even before we've adopted this legislation. Issues around duration. We're not quite sure why we need sort of evidence of right to occupy. It's beginning to get too cumbersome if you ask for the wrong or additional information, and crucially, contact details. It may be that photos, brochures, or mock-ups could be useful in order to sort of help move the issue along, but also crucially, I think how to evidence local and national conditions is going to be very important. So the plan, spacing, access, and so on, I think, are going to be very important, and we should consider them very, very carefully. So even though you don't require an operating schedule, I think a plan, for my part, is going to be crucial, and I hope colleagues might agree with that. There are some questions about the fees, so we'll come to them in due course. Notice to be affixed on the premises. I think what we're seeing nowadays is so many notices, because I've just come off a call where it said, put your risk assessment in the window, and you're going to have your risk assessment and your notices, and keep noise down, don't talk, no fun here, come and play quizzes and so on. So these windows are going to be barraged with that, but setting out the details of the application and where representations can be made. Those of you who are unfortunately far too familiar with me will have observed in our note the sentence that engagement with civil society is highly encouraged. That's absolutely me. You can see from Charles's reaction how much I had to fight to get in that. But I'm aware, because I've been contacted by various residents groups saying, how do we get involved? What can we do? How do we engage in that? And some residents groups are going to be really concerned about the impact on their area. So for my part, I'm not quite sure if Sarah's frowning as well, but for my part, engaging with civil society is going to be important, and letting them participate so they can make representations in writing. There's some confusion about the consultation period and the period of determination, because the draft says 7 days, the guidance says 5 days. We're following the bill for now, and until that changes, that is what we will stick to. The powers on determination, they can grant all of it, they can grant some part of it, or they can impose conditions, or even refuse the application. There's no power of appeal, but I think we're going to come to that when we deal with our questions. One of the things we did invite local authorities particularly to consider is that this legislation and others like it is all about promoting business and actually easing the burden on businesses, particularly where if you've got a small venue with limited capacity, its capacity is going to be limited even yet further. The addition of a couple of tables outside and some chairs is going to make a huge difference to the way in which they operate. Excuse me. We're going to have local conditions, we're going to have some deemed national conditions, including, particularly importantly, issues around mobility and access to the pavement by all. So that's going to be very important. The key consideration is going to be no obstruction. So even though there are no sanctions, save revocation, in this bill, the importance of not obstructing is going to continue to apply. And as far as I'm concerned, Part 7A of the Highways Act continues to be useful in respect of obstruction and so on. And I think based on the conduct of how particularly licensed premises, that's premises under the Licensing Act 2003, choose to operate their premises, we could even see the facts of the pavement license, the operation of the pavement license, and the impact coming in to be considered as part of wider review applications. So that's a very broad overview, which is already in the note that's been prepared by colleagues, and I think it's probably a good time there to pause and look at the questions. Sarah?
Yeah, happy with that. And I should have made it plain that there is an extensive note that accompanies this webinar that has already gone out. It runs to in excess of 20 pages, which sounds daunting, but it's set out as a Q&A. So hopefully it makes it manageable. You can actually scroll through it and find the question that is particularly bothering you with the answer there. So if you haven't already seen that or had access to it, do get in touch. And we will give you that copy. What I'm going to do, I've got 4 people with hands up, so I think what I will do is to come to them first, if those questions are proving a little taxing for the 3 of us, then perhaps we will park it for a moment or two and see if they come up elsewhere. But I've got Helen Farman first of all, who's got a hand up. Helen, I'm allowing you to speak. I've unmuted you. Do you want to ask your question? Bear with me. There we go, Helen. Are you able to speak now? No?
Thank you. Are you?
We can hear you now.
Hi, thank you. Yeah, I work for East Staffordshire Borough Council, and we currently do not have a pavement licence policy. We've got a number of businesses, mainly cafes in the town centre of Burton-on-Trent and New Toxeter, that already have tables and chairs outside their premises. Therefore, do they now need to apply for this new permit? Because obviously they would never have known about it beforehand. And secondly, we have a number of pubs in the rural villages that have tables and chairs on the highways. Again, would they need to apply for it now under this new permit that's going to come in?
Panelists clear on the question?
So hi. So you're saying that you don't have a tables and chairs policy, but you have a practice that already permits it in your local area. Is that right? Did I understand that?
I'm not, we haven't got one in East Staffordshire Borough Council, but obviously there's a number of businesses that do put tables and chairs outside their premises already. Some sell alcohol, some don't sell alcohol. So obviously that's the downfall there. That they've never been licensed before.
Helen, are you saying that they've just done it of their own volition without ever worrying in the past as to what regulations?
By the sounds of it, yeah, because a lot of the premises have been doing it for a number of years.
Well, on that basis, I suppose that they've been breaking the law and they might carry on doing that, I suppose. What?
Yeah, that's what our thoughts is as well. But obviously now, obviously with this coming in, obviously we're going, you know, the thing is, do we contact them and tell them now they've got to pay for it?
Well, isn't the answer that the existing premises have probably got deemed planning permission because there isn't a change of use, because it's a long established use? They don't need street trading consent because under the 1982 Act that they're not doing anything that counts as street trading. So far as highways are concerned, Helen, isn't that your county council that deals?
Yes, that's correct. To be Staffordshire County Council, yes.
So do you know if they've applied to the county council?
Not that we're aware of, no.
Yeah, well, it was the county council's problem, but it's now yours, I'm afraid.
Exactly, yeah.
The question is whether you need to go and start intermeddling with existing practices or just worry about new people.
Yeah, that's obviously what we've got to look at.
Nothing I'm saying is legal advice, but I would worry about the new people first.
Yeah, no problems. Thank you very much indeed.
Helen, I think this new law is for people who care about the law, and it doesn't sound like your constituents do particularly, so good luck to them. Right, okay, I'm going to come to Dave Gill next. Oh, the power, Dave. I get to allow you to talk or not. Go on, I will. Hang on, I'm unmuting you.
Hello, Sarah. I wasn't aware that I'd answered a question or raised my hand, so I apologise. There is just one slight thing on this, though. There is some dispute about who actually issues the licence. I know the application is made to the relevant local authority, but there's been some suggestion that the licences in Leicestershire might actually be issued by the Highways Authority, which seems to me to be slightly wrong, or definitely wrong. So a view on that would be appreciated.
No, I'll leave it to one of the other panelists, but the new bill is pretty clear as to who the local authority is. Anyone want to pick that up?
Yeah, the local authority is essentially whoever would be the licensing authority under the Licensing Act 2003, because the definition is identical. The only difference is if you happen to be in an inn of court. So we can forget about that. Essentially, it is whoever grants the premises licenses is now the same person who dishes out pavement licenses.
And in those circumstances, the Highways Authority, where we're two-tier, is just a statutory consultee in this matter.
Correct.
Thank you.
And that's set out in the bill itself. Yep.
That was my interpretation, but others take a different view.
No, you've got it, Dave. All right, I've got Helen Will, and I'm sorry if I don't know your names. I'll probably recognise you if I saw you. But Helen Will, can I bring you in?
Hello.
Hello.
Yes, it's Helen Wilson.
Hello.
Helen Will is my digital name. We're all moving in different circles now. We have digital names. Yes, Sarah. Hello. Yes, we do have. You have had interactions. I'm from Doncaster Council, and yes, you do know us. I've got 2 questions. Firstly, I'm very pleased to say that we have a very full and active alfresco policy in Doncaster. Don't we feel so smarty pants, especially when now you go, oh, a new regime that changes everything we've done previously, that adds in guidance from the Secretary of State with conditions that they could impose that we don't yet know about, that's going to come in after the lockdown releases on Saturday. Great, excellent. But yeah, welcome to the law. That's what we did it for. So my questions are, like many local authorities, we've got a public spaces protection order in relation to what I would recall the old DPPOs, the designated areas for restricting on drinking. And so most of the town centre areas have, you can't be with open vessels drinking. Now, as I understand the way the pavement licensing works, and we've got this sorted out for those with our current licensing, we've dealt with that appropriately, and the regimes are all carved out. The PSPO legislation says you can't put a PSPO in effect of an area with a 2003 Act licence. Now, as I understand it, and I entirely agree with you that adjacent to the premises cannot mean immediately abutting to, because you think about all the areas where you see waiters going across an area to see them. So what about these drinking areas that immediately going along with the government's guidance to open up establishments, let them have these, so they get the pavement license, and as soon as somebody takes their drink out, sits and starts sipping away at their chilled Chardonnay, they're going to be in breach of a public spaces protection order. And is that going to be the case, or do you see that actually the permissive element of the pavement license actually says if this is going to be allowable, it's an off license, it's a designated area for drinking for the off license? Is that going to get us out of jail in that respect? And the second question is, do we now have any idea when the Secretary of State is going to issue conditions? Do we have any idea what those conditions are going to be? Or do we have to say on our application form, here are our conditions, and there could be other conditions which may repeat the conditions you've already got, but subject to conditions, because we need to hit the ground running, as you say, for Monday, because some smarty pants may put an application in on Monday, and as I see it, there's a default position. We don't do what we're supposed to do when we're supposed to do it. Somebody gets a license granted without our ability to put any conditions on it. So
my quick rattle through on that. They won't be putting an application in on Monday. It won't be law by Monday. It'll take longer than that. We hope not too much longer, but it won't be by Monday.
Excellent. That'll please the drafters.
Secondly, do we know what the Secretary of State's conditions are? No, other than what's in the bill already that's transparently there. No, we don't, but your conditions take precedence anyway. So I don't think you have to worry an applicant with what the Secretary of State might do. Your conditions would take precedence unless it's a deeming situation, but you can't worry about what you don't know about. So unless Secretary of State produces something.
Oh no, Sarah, we can. We definitely can.
Oh, go ahead, worry away. You've got plenty to worry about at the minute. PSPO, very quickly, I'm going to pass this over to the other panelists, but my take on PSPO, you're quite right to say that the pavement license has got nothing to do with extending a premises license, completely separate things. It's not extending the premises license out into the highway and the pavement. PSPO is all about the police having the power to pick up people who are drinking in a particular way.
And it's the individual, not the establishment, of course. Yeah, so it'll be the customer, the patron that's actually in the frame. Yeah.
That's right, but in terms of the relationship between PSPO, I've not seen anything in the bill that makes an express exemption. So quite how that relationship works, either of our panellists have a view.
Well, section 62(1)(e) of the Antisocial Behaviour, Crime and Policing Act says that a prohibition in a public spaces protection order on consuming alcohol does not apply to a place where facilities or activities relating to the sale or consumption of alcohol are at the relevant time permitted by virtue of a permission granted under section 115(e) of the Highways Act. So a public space protection order doesn't apply to a Highways Act permit.
Yes.
However, I haven't seen anything in the bill extending that to a pavement license. So
Yeah,
is
that's my problem. So,
Yeah.
so we were quite happy that all the areas we went, made sure we actually covered it off and made sure they all had off-license sales as well, to make sure there was there's no issue whatsoever. But absolutely, that is a very important consideration, where people will automatically be in breach of a public spaces protection order by virtue of us giving a pavement license that's under the new regime.
Well, all I can say is Doncaster's 10 paces ahead of everybody else. I certainly hadn't spotted
As we always are.
and it's not in the bill. And perhaps somebody needs to find a friendly peer to propose an amendment, because that.
Well, the solution is obviously enforcement of the a PSPO is very much down to the local authority. It's not a requirement to enforce it. And the new word I'm hearing is that we need to be permissive. If we're going to allow, it'd be very odd for us to allow a pavement license under the new regime and say, there you go, police, there's a nice little nice little fishbowl of people who are in breach of a PSPO. You can go and find the lot of them. So it seems
Are they automatically in breach, Helen?
Yes.
Isn't it down to behaviour?
No, it's the mere fact of having an open vessel of alcohol.
It seems to me that certainly there's a lot more work to be done on this, and it's not clear because I've not seen anything either. But one of the effects of this bill is to extend what essentially is the private realm of a licensed premises into the public realm of the pavement, and it may be that begins to find an answer to this. While I've got the mic, Sarah, I don't know if you're aware, but it's not just the people that have got their raised hands, but there's also 28 people who've listed in the Q&A.
I have spotted it. I'm working my way through.
Leo, you have raised it. I have taken up an awful lot of your time. You have just answered the question that I thought it is an issue for us to be aware of. And I'd be very surprised if a lot of areas don't either have DPPOs or automatically transferred into PSPOs by virtue of the antisocial behaviour legislation in 2014.
It's come up a lot, Helen. It is a question that's come up several times. Let me move on to. Thank you so much. Thank you. I'm giving priority to people who are brave enough to talk. So got one more of those. Got Daisy Gadd. I'm going to bring you in, Daisy, if that's all right. Have I unmuted you? There you go. Can you talk to us, Daisy?
Yeah, hi, I'm Daisy Gadd from Westminster City Council. I've just got a question in terms of whether the pavement licence only permits the placement of furniture on the highway, and then whether in terms of any other street trading, would that have to be regulated under our current legislation, such as the City of Westminster Act? So whether that pavement licence is purely for furniture and then any other trading would take place under a different licence. And then just another separate question which relates to conditions. Obviously the government have spoken about it being table service, but is there a general consensus that will also be to persons seated? And is the local authority able to make those types of conditions so that it would be to people seated and also maybe to an ancillary table meal?
Well, for my money, that's going rather far in terms of the conditions need to relate to the authorisation. So to start to impose what would effectively be conditions on the premises licence, sale of alcohol, ancillary to meals and so forth goes too far for my money. What do our panellists think?
So, firstly, in terms of the first part of the question, the use of these tables and chairs is for the sale of food or drink. So as long as the trading is restricted to that, you wouldn't need a street trading license. But if they also started to sell other items that weren't food or drink, then that would fall into street trading. The conditions under the pavement license can only relate to the pavement license itself and not to the premises license. So in terms of restrictions that you might want to have in terms of what items of furniture, where they can be located, even times, because that's one of the questions in the Q&A box, the times of the pavement use can be different to the premises license. That doesn't have the effect to change the premises license, however.
Okay, cool, thank you. Yeah, thanks.
Thank you, Charles. You happy with that?
Yeah, there's nothing I can really add. That the except to say the authorization of the license, what it authorises is restriction of public access to the highway, but then it also provides that anything done pursuant to the license, which is putting the furniture, and the furniture is defined within the Act as 4 categories of furniture. Anything done pursuant to it is not street trading. So as long as you are doing things pursuant to the placement of furniture, it's not street.
Okay, cool.
And Robert Botkay in the chat makes a very good point. What if you've got conditions, which is to turn your question the other way, Daisy? What if you've got conditions on your premises license which will make the operation of the pavement license difficult? And I think what you need to possibly be doing there is, when you make your application, for those of us that are going to act for the applicants or advise them, they may need to bring to the attention of the local authority that there are conditions on the premises license that wouldn't let them necessarily be on the outside area, and use the pavement license to almost to amend the pavement license, the premises license specifically for the use of the pavement. I've just sort of really been thinking that through since we've been on this webinar. I don't know what Sarah and Charles think about that.
Yep, I would tend to agree.
This is maybe this is the new normal. This is the new normal. Barristers agreeing with each other.
Right, that's my speaking, people. So thank you very much for that. Now we'll start to wade through your Q&A. In fairness, some of these have already been picked up already, but we'll see what we can do. And I've noticed there are questions in the chat as well. So I'm going to start at the beginning. Dave Overridge wants to know about offences. There's no offence of putting furniture on the highway without a licence. So what can a district council do? And this really comes back to Helen's query earlier. What can you do with premises that are putting furniture out that don't apply for a licence? Because there are a number of premises, I think, who've already eyed this facility up. We were talking about people who wanted to make an application on Monday already, before the law actually comes in. What are they doing wrong if they don't have a pavement licence and they've got their furniture out? Well, you remember when I said right at the very beginning that that there are five different pieces of legislation engaged when you put chairs and tables out on a pavement. I guess they would be in breach of all of those things if they don't have a Highways Act pavement licence or a new pavement licence. But what do our panellists think?
Yeah, there's the offence under section 137 of the Highways Act can be prosecuted not just by the Highways Authority but by anyone. There are some restricted offences in the Highways Act, but even those I think can be prosecuted by local authorities. The section 137 offence isn't one of them. So far as I'm aware, the fixed penalty regime isn't in. There is a fixed penalty regime under the Highways Act, but it's not in force yet. And the other options are planning, and there may be some obstructing the highway regime, obstructing the highway offences, common law offences that can be pursued. Yeah.
Okay.
Agreed.
Charles, we're just occasionally losing you, Charles. If
Yeah,
I don't know if you're closer to your microphone.
I'm getting furious text messages that that's the case. I don't know. I'm not entirely sure why, because the microphone is right in front of me. But I'll try another mic.
Lean in nice and close. We've got several questions about fees. I'm going to try and roll them together. I've been asked, do you have to take a fee? Your maximum is 100, obviously. You can only take up to 100. You can take less than 100 if you wish. I can't see any reason why you should not choose to waive a fee entirely. Do the panelists disagree with that?
No.
So you don't have to take anything if you don't want to. And we've seen a number of examples of authorities prior to this bill being on the table waiving and deregulating, trying to help out their local businesses. So yeah, you can have less. The related question to that is from Anonymous: do you recommend collecting fees for the application? And presumably then, do you have to give it back again if the application doesn't go through for some reason? What happens if premises haven't got enough space as stipulated in the Act? Do you give the money back?
I'm always against giving money back. I know there are lots of trade people, but when I advise local authorities, this culture of, well, I haven't used my license or I haven't used it for very much, can I have some money back? It's very generous of the local authorities to do that, but there's no legal requirement on you to do so. It's cost you as much to process, review, look at your inspections, your policy. All your costs are still the same, whether or not the license is granted. And let's face it, it will be granted, it will be refused if the applicant hasn't considered things like access, things like mobility, hasn't done their work, hasn't provided a proper plan. And so potentially your costs are greater when you're forced to say no. But that's me with a very local authority hat on. When I'm acting for the operators, of course, I want full refund and a hamper with apologies.
But since we're dealing with the law, we'll go with the first one. Several questions from separate quarters talking about areas that are not highway, not pavement. So outside spaces like car parks and beer gardens and greens and all of that kind of thing. To make it very plain that this provision in the bill is all about pavements, it's all about highway space, and that is defined. The supplementary question that I've got from Tracy is for premises who want to use their own outside spaces, private spaces such as car park, don't need a pavement license, do they need to apply for a variation of their alcohol license? Well, that will depend, won't it? That will depend upon where the red line goes. It will depend upon what they're putting into their own private space and how that relates to the planning permission that they've got, the extent of the planning unit, any material change of use, that kind of thing. Slightly outside the remit of this webinar, but in principle, nothing to do with a pavement license, and the answer is it will depend. As to what else they might need in those circumstances for a private space. And I'm sure there'll be more debate about private spaces as time goes on, because lots of premises will want to do that. Similar question from Brian on that. Does the furniture have to be adjacent, that's next to or adjoining the premises, or can they apply to utilise open green spaces and other pedestrian areas within walking distance? Well, adjacent is the word in the Act. Do either of our panellists want to pick that one up?
I think something, well, firstly, an open green space isn't a highway, so pavement license doesn't apply. There was a question about village green. It's a criminal offence to place materials on a village green under the Enclosure Act of 1857, and also a statute. Yeah. So I'm afraid village greens are a no-no. I think if you're having to commute to the area, then it is probably not adjacent. I mean, it's very difficult to draw a line. I think there can be. I mean, certainly in Newcastle, there's a proposal to keep the pavement, the footpath where people go, to leave that for pedestrians, but then in what was car parking spaces to have the pavement cafes there. They're not contiguous, but they're certainly adjacent. But I think if you're going around the corner, that's not adjacent.
I've dealt with an example where the pavement in front of the premises is quite narrow. And if you cross the road, there's a wider bit of pavement behind which is not a green space, but actually a village green. So obviously Charles's considerations now come into play, which I have no idea about. But I think that the pavement on the opposite side of the road facing the premises would be permissible, and there would be it would be appropriate to do that there. Sorry, I got caught by the update. Second reading 6th of July, which I knew about. Committee 13th of July. Report and third reading 20th of July. We're clearly moving with great alacrity here. Wonderful. But yeah, I think looking at the spaces and thinking about them is probably something that local authorities want to encourage when you're thinking about social distancing, physical distancing, spacing, control of the public realm. I think it's the interest of the local authority to consider being creative and not narrowly defining where adjacent actually might be. Sarah?
So it turns out we need not have quite so hastily convened this webinar after all, but we're here now, so let's enjoy ourselves. Right, question from Gemma in Wales. Hi, Gemma. This is a sort of another flip side of the coin kind of question. Main question that's arisen so far, she says, is in relation to alcohol sales from outside areas, outside the licensable area of the premises. Will there be permission for this and where will it lie? Nothing to do with this bill. And nothing to do with pavement licenses, Gemma. Alcohol sales controlled as ever by the premises license and must be appropriated to the contract. That's a phrase we're all familiar with, within the licensed premises, so within the red line. Now, sometimes red lines do go outside of the building, sometimes they don't, but it's not affected by the pavement license. Any additions to that, chaps?
No,
sorry, I'm just reading a WhatsApp message Leo's sending me. Yeah, no, I mean you can sell. Obviously, this will be a familiar territory for some and less for others. You can have table service outside the red line. So a waiter, waitress can come and take an order, go back in, get the alcohol, bring it back out, take payment outside. Everything can happen outside. The one thing that has to happen within the red line is the appropriation of the alcohol to the contract. So from a contract lawyer's point of view, the place where there is an unconditional appropriation, the place where the bottle is open or selected or put on a tray, that has to happen within the premises. But everything else can carry on outside under off sales, which is about to be extended or where it didn't already exist.
That is a point to pick up on, actually, and I think Robert Bockey's asked that question and said, well, surely pavement licenses are related to the off sales facility coming through in the bill, and that is true to that extent that Charles has just made that point, that if licensed premises did not already have the facility to supply alcohol for off sales, consumption of the alcohol off the premises outside the red line, they will automatically get that facility within the bill when it comes through, with certain exemptions if they've been deprived of that authorization in the past for some reason, or there's been issues with it, but they will be able to serve for off sales if they haven't previously. So that would go together with their pavement license. Right, minimum period. The minimum period under the bill is 3 months. You cannot grant a pavement license for less than 3 months. I've been asked, can a license from market be issued for a weekend only? Well, a license from market and a pavement license are not the same thing. You could grant a pavement license for the minimum of 3 months, and then somebody uses it for less than that if they choose to do so. They don't have to use it for the full 3 month period. They might want to have it for less. It's just you can't grant it for less. Any additions to that, anybody?
No, agreed. Only to say I'm so grateful for all the questions. It looks like we're going to have to start working on version 2.
Yeah.
Because you have some really great ideas. And those of you that have been asking the really difficult questions, expect a draft for you to check and comment on and contribute in due course.
You have to play.
But no, I think the duration, minimum 3 months, if the person doesn't want to use it every day, that's absolutely fine. And you can also condition it to being used only on a number of days, I think.
Yes. I can't remember exactly how long this webinar was supposed to be going on for, but we're just going to carry on with these questions until we've finished. If you need to leave, you can, but the rest of us, we will be here until about 11 o'clock this evening. So on to the next question. Oh, well, this is a really big one that keeps coming up all the time. Is it an executive or a non-executive function of the council? Several people have asked this. And then there's a follow-up question here from Paul Jones saying, is it subject to members' approval? So is the pavement licensing procedure subject to members' approval and acceptance into the relevant authority's constitution? So I'm going to pass this over to Charles or Leo. I know you've answered this several times already in different formats. So is it executive or non-executive, subject to members' approval? Does it have to go into the authority's constitution?
Okay, I'll stick my neck out. The default position is that a local authority function is an executive function. So at the minute, it's an executive, well, it's obviously not been passed yet, but at present, it looks like it's going to be an executive function. People are saying there's nothing in the bill about it. Well, there wouldn't be anything in the bill about it because the specification of whether functions are executive or non-executive must be by regulation, which is what Section 9D3 of the Local Government Act 2000 says. So currently, under the existing allocation of functions regulations, which are the 2000 regulations, both pavement licensing, pavement permitting rather, under the Highways Act 1980 is a non-executive function, and street licensing is a non-executive function. It's within the power of the minister to amend those regulations to add pavement licensing, but if past experience is a guide to future performance, they don't amend those regulations with any alacrity, because anyone who's had anything to do with scrap metal licensing knows that that's still not been indicated to be a non-executive function, even though there's a draft regulation that says it should do it. So in my view at the minute, unless something changes, it's an executive function. The question then is who you can delegate that function to. The draft guidance suggests that the licensing committee can review the decision, and it's been pointed out, well, the licensing committee is a member committee, it's not an executive committee. So how can it do that? I know that Jim Button's written an article that says you should actually have two licensing committees to deal with the executive and non-executive functions. It's probably too big a topic for this webinar to come to any conclusion as to whether you could actually delegate an executive function to a non-executive committee just for the purposes of review. I don't see why not personally, but there may be somebody with a very passionate objection to that. But at the minute, it looks like an executive function, and it would have to be subject to a suitable delegation, but that could change if the regulations are amended.
I see in the chat box that certainly at least one local authority has a different view.
Yeah.
Given the popularity of this particular question, it's a question we're going to be looking at really carefully and providing a more detailed answer in version 2, which will probably come out a lot quicker than the bill and the Act itself.
And they'll probably base the bill on our question and answer document, because it would be better
if we get it up.
Yeah, very good. Paul Jones has also asked a supplementary question. Why has central government not prescribed application forms, conditions, etc., and why have they left it to each individual local authority? Paul, it is because they hate you. Right, moving on to the next. Why anything? Why anything? But they haven't. It leaves a lot to be desired. Right. Yeah, so this business about going back to Helen's question earlier, I've got another Helen Clark, talking about bending and breaking rules. So what about these licensees that want to get tables and chairs out a little bit too quickly, a little bit previous to the bill coming out? Helen Clark says, can we extend existing street trading licenses which have expired during lockdown to bridge the gap before issuing pavement licenses? Well, possibly. I'm not sure it answers the same purpose as the pavement license. Any thoughts on that, anybody?
This is under which act? Is this a London?
It doesn't specify.
I'm
I don't know that it helps particularly, does it?
No.
No. Dangerous question to answer off the cuff, I think.
It is really, and I don't know that it's not. It depends upon what the licensee actually wants to do. Of course, if they need to do something that is covered by a street trading license, then they should have one, and but it won't be a substitute for the pavement license, which is specific to the furniture. Dave, that's quite a complicated question. Dave Etheridge, I'm going to just pass over that for now because I think we might need a moment to think about that one. Adjacent, we're coming back to adjacent still. In the, what is IIRC? Robin Levitt, IIRC, the regulation specifically extended the meaning of adjacent, but the bill doesn't. Does this not imply different treatment? No, I don't know that it does. I wouldn't say so. Some of these questions are now quite lengthy. Chaps, have you got a quick question that you want to fill in on while I'm just going through these?
The decision making, we've had a question about decision making, and it's how should local authorities approach decision making, because under the bill they can grant their license taking into account traffic issues, preventing obstruction, and use of vehicles in such a way to prevent access and so on. And the question is, well, what about issues such as noise, safety and so on? Now, I think those issues around noise and safety can be imposed as conditions if granted, but the main ground for objecting is to deal with obstruction on the public highway. Charles, do you see that question?
This is
going back a few. Tony Hawks. So are the refusal ground limited to the grounds listed in 3.6, or could matters into account? Jordan, is it?
No, it's what I would describe as an unfettered discretion with a there's a mandatory I'm
just getting the relevant clause up.
So am I. So it's 3.5. A local authority may grant a pavement licence only if nothing done by the licence holder would have an effect specified in subsection 6, and those are effectively obstruction. So if it's going to obstruct traffic, by which they mean pedestrian traffic, permitted vehicles, the gas man, Virgin Media. If it's going to obstruct any of those 4 categories of people, then there is no jurisdiction to grant. But otherwise, they may grant. So that's an unfettered discretion. So any reason they've got that isn't irrational can be a reason for refusal.
We've got a couple, speaking of irrationality, we've got a couple of questions around having a blanket time, 10, 11 o'clock for closing as local conditions or conditions that apply to particular areas. For my part, I don't see that could be a problem. What do you two think?
I don't like it because I think each application on its merits, it relates also, doesn't it, to some suggestion that there might be a blanket minimum, so everybody gets 3 months or 4 months or 5 months, and I'm not comfortable with that, because I think each application needs to be looked at in terms of where it is, what's required, how much furniture and so on and so forth, and that might make the difference as to the hours and the terms that you provide, the bespoke conditions that you would want to provide for that application. So I'm not comfortable with a blanket anything. And if you relate it back to Licensing Act 2003, we're expressly discouraged from having blanket conditions. Conditions are supposed to be evidence-based and meeting all the tests for conditions. So that's my take on that.
But if you've got, say, an area of cumulative impact or a high street, or you've got particular challenges around policing, regulation and resourcing, you've got controls in the public realm about buses and people and where they want to come and go, I think having conditions which say in this area tables and chairs need to be removed by this time is something that I would happily defend and take Sarah on. Charles, do you want to meet?
Oh, mediate between us. No, don't. Well, we've got our first case over here.
I think you've got to. I think you've got to. I think you should have a cut-off time as part of your standard conditions. For the one reason that it's a slightly different reason. The 5.2 says a local authority may publish conditions subject to which it proposes to grant pavement licenses. If there is a deemed grant, which there may be quite a lot of deemed grants if local authorities find they simply cannot keep up with the number of applications coming in. If they don't publish those conditions, then the deemed grants are not going to have any conditions on them, because a deemed grant gets the standard conditions put on automatically. So there is actually, if I was being led by Leo on this, I would be saying, Leo, what about this point? That unless you have that, it becomes a 24-hour license for anything that's missed. The 5.1, that the power to have conditions is that they've got to be reasonable. That must be in each and every case. But I think it's quite hard to think of a place in the densely populated country in which we live where it's okay to have people using tables and chairs on the street 24 hours a day and an 11 p.m. or a 10 p.m. cutoff. I think that there is some argument that that's reasonable. I know it would be different if we're in central Madrid, but we're not. My view, local conditions are very important, because if anything gets missed, that's going to not have your general policy conditions on it. But the way the Act works is that each application has to be decided on its own merits.
I think that's the important part, and that's the point I would take away. I don't necessarily disagree about a policy. As we know, in most circumstances, and certainly within licensing regulation, you can have a policy. You must be able to depart from that policy under certain circumstances. It must never be absolutely blanket imposed. And where you've got a specific application that you are determining, I think it would be very wrong in those circumstances to say nobody is ever going to get more than 10 o'clock or 11 o'clock out of this authority. We will never grant that extension to anybody under any circumstances. That, I think, would be legally challengeable. I hear what's being said about the deemed and the conditions, and that might be a slightly different matter, because that might be a policy situation. But I think there's a word of caution there.
Sorry, because it built on this, so there's a question about an operating schedule. There's no requirement of an operating schedule, but if you look, you need to identify your premises, the part of the premises you're going to use, how you're going to use it. Is it food or drink? Is it both? Is it for seating or what have you? In effect, operational matters, what days of the week you're going to use it for, the type of furniture, and the hours between which you're going to use it for. So there's quite a great deal of information that is being requested under the application form, which in effect are saying how are you going to operate your pavement license. So it's not called an operating schedule, but they are asking for all this information.
Okay, we've got a question from Richard Taylor, Gostrocks. Hi, Richard. Wanting to know what the relationship is between a new pavement license and an existing highways license, pavement, highways, tables and chairs license, whatever you want to call it. So firstly, the question is, if you've already got a Highways Act license, a tables and chairs license, you won't need a pavement license, presumably. I dare say that that's got to be right. Why would you need it twice if there's nothing wrong with the facility that you've already got? But the second part is actually dealt with specifically in the bill, which is what is the position where you're in consultation, you're going through that Highways Act application for your tables and chairs license, and now the new bill sweeps in with a new pavement license. Well, the bill actually picks that up particularly and says, in essence, that the pavement license process will take precedence, but you can't be charged both fees. So I can't remember which way around it is, whether you get refunded your Highways Act fee or whether you don't have to pay your pavement license fee. But either way around, you move on to a pavement license. Anyone want to nuance that a little bit?
Yeah, it's clause 7 9 and 10, and the way around is that you can't be charged a fee for your pavement license application. Your application for a Highways Act permit is withdrawn. It isn't automatic. It only applies where you apply for a pavement license. So if you've got an ongoing Part 7A application, and before that application is determined, you then apply for a pavement license, your Part 7A permit application is treated as withdrawn, and if you paid a fee in relation to that, you can't be charged a second fee for your pavement license. So it's not an automatic provision.
Just because, yes, no, I agree with that. A question that's popped up, which I think it's useful to deal with before we close, is actually, do you think the proposed use is wide enough to cover the retail outlets, provided a seating area waiting for customers when they will sell or provide refreshments? And we all do think yes, David.
We do.
We put that in our note.
Yeah. What time did we say we were going to stop this?
Past 90 minutes, so we need to
start to wrap it up. Well, there are plenty more questions here. We will collect them all, and hopefully we have gone a long way to answering the key questions that come up over and over again. But we will go through all these questions and collate them and provide a second note in due course. But thank you very much indeed to everybody who has participated. I can see there are questions in the Q&A and questions in the chat, so we'll go through those and make sure we record them carefully and come back to you on them. But we've had 250 participants with us today, and it's been very nice to hear and talk to you all. So on behalf of myself and Charles and Leo, thank you very much indeed for tuning in, and no doubt there will be more from us in due course. But enjoy the rest of your afternoon, and thank you very much indeed, and you are now all free to go. Thank you.